Hey, what's up everybody? This is Mike Riley, and in today's video, I'm gonna talk about why you should never ever talk to the police, at least not until you've talked to a lawyer. Today, you can expect to learn why the police are so interested in getting people to talk, some of the tactics that police officers use to get people to talk, and why you should never ever talk to the police. Some people say you should never talk to the police without your lawyer present, and I can tell you that I get calls pretty routinely from people that are saying, Mike, the police want to talk to me and I'm no idiot. I'm not going down there without you. And I say, yeah, well, that's cool, but I'm not going with you. We're not going. I'm not going. You're not going. If you've ever watched Law and Order, you see that the lawyers in that show routinely take their clients down to the police precinct to be interviewed, and the lawyer sits there idly by while the police ask the client questions and the client gives answers to these questions. Bad idea. I almost never take my clients down to speak to the police officers because the police officers are generally there to get incriminating information to be used against my client at trial. So why am I going to sit there next to my client while I let them answer questions from law enforcement? It's just not a good idea. I'm not saying I never do it, but I'm saying in the vast majority of circumstances, I would not take my client down to be interviewed with the police. First, it's important to consider why the police are so interested in getting people to talk. And the reason is because in criminal court, a defendant's statements are exempt from the hearsay rule. So hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Okay, generally out-of-court statements offered to prove the truth of the matter asserted are not admissible in court. There are several exceptions to this rule, and the one we see most often is the defendant's own statements or admissions. They are exempt from the rule. They can be used against you. And it's very compelling evidence. I've seen many cases that were very weak until someone went down and spoke with the police, gave information that implicated them, and ultimately led to their conviction. Now, you might be thinking, well, I could talk to the police. I'm just not going to admit to doing anything. I'm not going to confess. How bad can it be? Well, I've seen people get themselves in a lot of trouble going in and even denying their involvement. So if they can catch you in any sort of lie, that can be used against you to suggest that you're lying about something, that you're covering something up. This is what we call consciousness of guilt. I once represented a guy who was a suspect in a homicide, and the police interviewed him before he came to me, and they said, where were you at the time that the homicide occurred? This client thought he was smart. He could talk his way out of it. He said, oh, I was over at my friend's house. The police followed up. Where does your friend live? The client gave an address. The police went and knocked on every single door in that neighborhood. Many of these homes had home surveillance systems. The police recovered their surveillance, watched all of it, and were able to show that the client was lying about where he was at the time the homicide occurred. Now, this was not a confession, but it suggested that the client was lying about his involvement in a homicide. And by the time the client came to me, he had already kind of backed himself into a corner, boxed himself in, and the state had a very compelling case against him. Now, the police want people to talk. They recognize that this is very compelling evidence, and they have several techniques that they use to try and get people to talk. One classic example is good cop, bad cop, right? You have one cop who's tough, who's menacing, who's threatening, and then you have another cop who acts friendly to the person, soothes them, comforts them, tries to make the person feel safe, like they can confide in them, like they're there to help them and protect them from the bad cop. Another tactic we see is police officers who tell the client, listen, I could talk to the prosecutor. I could talk to the judge. I could tell him you're not a bad guy, but you need to give me something to work with here. Basically suggesting that they can somehow influence the court process only if the client, the defendant, starts to give some information up. Do not fall for this. Your lawyer is the best person who can handle the court system. You do not need a police officer advocating for you at court. You need a criminal defense lawyer who is experienced, competent, and knows how to handle these things. Another tactic that police use is suggesting that somebody's going to look really bad. Like, these facts are really bad. These facts make you out to be a monster. I don't think you're a monster, but you got to help me. Maybe it was an accident. Maybe this didn't go down this way. Offering an opportunity for the client, the defendant, to minimize the behavior, to explain it away. And a lot of times people take this bait and they decide that this is their opportunity to essentially mitigate the nature of the charges, talk them down a little bit. Again, really bad idea. Let your lawyer do this in court. And that's essentially what your lawyer is there for. Your lawyer is there to take your case through court, through a trial if necessary. If there are arguments to be made that, hey, this is not what it looks like, or hey, this is a good guy, or this is an accident, or my client wasn't there, the lawyer is the one who needs to be making these arguments, these statements, not the client. If for no other reason, then the lawyer's statements can't be used against the client at trial. Now let's go back to the example of the guy who said he was at his friend's house at the time a homicide occurred. Now, if I was representing this guy in court and I went to the prosecutor and floated that idea, and the prosecutor had the police go track down the home surveillance and show that it wasn't true, the fact that I said that he was at his friend's house, that can't be used against him. But that's not what happened. In the example I gave, the client is the one who told the police that information. They were then able to use his statements in court and show that he was lying. They can't use the lawyer's statements against you. They can only use your statements against you. Your lawyer is there to strategically take you through court. They know how to do this. They can advocate for you. They can make these arguments and they in no way blow back on you. Now, there are times when it would make sense to have your client go in and talk to the police, but they are few and far between. More often than not, it's just not a good idea, and I would not recommend that you do it. If the police want to talk to you, at least call a lawyer, call somebody who you can trust and say, this is what's going on, and always think twice about going down and sitting down with law enforcement, especially if they're investigating you, investigating your involvement in a crime. They're going to be looking for you to make statements, to admit things, and really to implicate yourself. And if you do that, you very well might find yourself in a jail cell. So what do you think? Do you think it's a good idea to talk to law enforcement? Do you think you're clever enough, smart enough to talk your way out of something? Do you think lawyers should walk their clients down to the police station and sit there while the clients are talking to the police? Or do you think it's a better idea to just not make any statements to the police officers? I'd love to hear your thoughts and comments below. If there's anything else you'd like to hear me talk about, please let me know. Like, subscribe. I appreciate all of your support. Thank you so much for watching.